Prep YouTube channel. I'm Ashish Bhargav, and today I welcome to each and everyone here again the another episode of Deep Dive. And as we know that this deep dive session is important for especially for the students who are preparing for the CLAT exam. And one more thing that you need to keep in mind is that the today deep dive is very important. That is daily in the news after appointing the 50th CJI, and so we will got to know what is the constitutional provision to appoint the CJI, what is collegium system, and we can say functioning of judiciary. The main focus would be on functioning of judiciary. Then we go to the next article is 50th CJI. Now about current affairs is the best way to know about current affairs to study newspaper and magazines. One should study magazines on a daily basis to be updated by current affairs. Now the quote of the day: little progress each day adds up to big results. And the capacity to learn is a gift, the ability to learn is a skill, the willingness to learn is a choice. So try to improve such kind of a skills, which is very important. And as we know, the Henry Ford wrote, failure is the only the opportunity to begin again, this time more intelligently. So here the very first article is from the editorial sections of Indian Express. So here is mentioning about, and the person, the writer is Felice Nariman, is a, we can say, constitutional jurist and senior advocate to the Supreme Court of India. As we know that live old stocks and we can say judicial institution need to be oiled, bounded up and set up to the true time. So the Supreme Court is the final judgment in our apex court, is known to be apex court in our country, and Article 141, which is mentioned about the constitutional amendment, is binding to all other courts and authorities in the country, as it is mentioned in the Article 141. The term it is used, judicial governments. Judicial governance, which means that all judges who are constitutionally instructed with the responsibility of protecting the rights of citizens must also be seen to be person to rectitude. And we need to understand they must make annual financial disclosure statement, not privately to their respective Chief Justice but publicly. It is done by Chief Justice of Supreme Court in the world oldest democracy, the US, and it's appropriate that all such disclosure statement of its judges be made and then also published in the world's most populous democracy, India. We will discuss deep, but before starting this one, we have to understand our judicial structure in our country. Here is the second article, as we can see, how to grease the wheel of justice. The problem of pendency of cases in court across the country can we tackle a few measures. And then, as we can see, judiciary should not be seen as a closed hub. While our new CGI has effectively defended a collegium system of judicial appointment, let us also acknowledge that a push for greater openness would aid the larger cause of justice. So if we look at very carefully, we will got to know, ये भी article में discuss the new Chief Justice of India हमारे country के बने हैं, D.Y. Chandrachud has assumed office and crucial moment in public affairs. Barely a week ago, we can say, Union Law Minister Kiran Rijiju has spoken out against that he had called opaque system of judicial appointment and said the judiciary should stay off the executive domain. But our history tells us a powerful government backed by a massive mandate tends to stymie judicial independence, even trample democratic value and civil rights. All this juncture when principled dissent anti-terror laws used to squash protest and protester, and independent judiciary needed all the more acutely to safeguard our rights. So what exactly is the NGSC and collegium system? In many ways that we can say that Supreme Court decisions to strike down the National Judicial Appointment Commissions in 2015 as unconstitutional and retains collegium was meant to protect this were autonomy, but as we have seen since then. So in an interview to the Indian Express, he said to the best way to deal with criticism to work in a manner which more accommodating diverse critics of the working of collegium. So it's for the CGI to look within the push for a greater openness without yielding the populist pressure. So we need to understand the first nitty-gritty is NGSE and collegium system. As you know that, so collegium is system based on the 3 judges cases. Under it, appointment of judges are made by Chief Justice of India and most senior Supreme Court judges. Has no constitutional backing. And what about NGSE? NGSE was a body created to end the 2-decade old Supreme Court collegium system of judges appointing judges. Constitution of India Article 124 says appointment to be made by the President in consultation with judges as President may deem necessary. So this article need to be important with the perspective of your exam. Article 124. With consist of 6 people, if you talk about NGSE, CJI, 2 senior most Supreme Court judges, law minister, 2 eminent persons. So what is the procedure is that to appointing CJI? First, the collegium system make recommendations that XYZ person, for example, that this person is eligible for the fulfilling the post of CGI. Then the law minister give recommendation to the chief Prime Minister of India. Then Prime Minister recommended yes, this person is suitable for our country and all. But this is not bound to follow this. Critics say judges in NGSE will need support to other to push a name through. They fear judiciary independence being compromised. So recently some expertise in which says the need to revamp the judiciary system in India because the reason Indian Constitution has established an integrated judicial system with the Supreme Court at the top, which is known to be apex court, and High Court below it. Below the High Court there is a hierarchy of subordinates court. The single system of court adopted the Government of India Act 1935. So we can say that the single system of court that we have adopted from where? Government of India Act 1935. Enforces both central laws as well as state laws. Now as we know the hierarchy of the Supreme Court. What is the role of Supreme Court? Its decisions are binding on all courts, can transfer judges of High Court, can move cases from any court to itself, can transfer cases from one High Court to another. What is the role of High Court in this? Can hear appeals from lower courts, can issue writs. Writs matlab, what does it mean the word writs? Writs, which means we can say that in the violation of fundamental rights, fundamental rights, Supreme Court and High Court can issue the writs. In Article 232 and 26 we can say. So can issue writs to restoring the fundamental rights, can deal with cases with the jurisdiction of the state, exercise superintendence and control over court below it. And then we can say that district court deals with cases arising in the district, considers appeals on decisions given by the lower courts, decide cases involving serious criminal offences, and then below district court then hierarchy subordinate court की आती है. वो क्या करते हैं, वो बहुत सारे केसेस को कंसीडर करते हैं सिविल और क्रिमिनल नेचर्स के. ठीक है. सो हायरार्की should be first is Supreme Court and then High Court, then District Court, and then we can say subordinate courts. The legal system is divided into 2 branches. One is criminal law, which is concerned with any citizens or corporation committing a crime, and civil law, as we can say, that deals with disputes about a citizen's fundamental rights being violated. And as we know that in the Supreme Court in our country is an apex court, and Supreme Court is below than a High Court, and that we can say metropolitan courts and the district and session court also. And the metropolitan court that has to be divided into 2 parts, which we can say civil court and criminal court, and district and session court that we can say civil and criminal. But here city civil court, session court, and court of smaller causes, chief metropolitan court, and here is we can say different hierarchies, district court, session court. They have a different same terminology but different cases. So Indian judiciary, that we have to understand that the judiciary is the arm of government responsible for interpreting the laws, resolving disputes, providing justice to all citizens irrespective of which caste, gender they belong. And the judiciary is seen as the custodian of the constitution as well as the watchdog of democracy. It is the critical for the democracy to function properly, to have an unbiased and independent court. And what is the characteristics of this? Indian judiciary characteristics are one of the oldest judicial system in the world. The judicial system of India is one of the most well known in the world, which is employed to interpret and implement the laws of the land. The doctrine of separation of powers allows the court to authority to interpret laws as they see fit. The judiciary does not create statutory laws for the country but rather interprets and applies them. And single and integrated judicial system. In India, as we can see, the constitution established an integrated and distinct judicial system. The Supreme Court is at the very top of the combined system. Following the Supreme Court, there is a state level high court also. There is a well organized structure of district court, and then we can say that we have independent judiciary. Independent judiciary. It implies that executive and legislature branches of government do not interfere with the judiciary ability to function. Other organs accept the judiciary ruling and do not interfere with it. So it also implies that judges are free to carry out their duties without fear of reprisal, and the judiciary independence does not imply that it operates arbitrarily, which means that अपने मनमानी तरीके से वो नहीं कर सकते, and without regard for the law. It is responsible for the country's constitution. And we can say that, as we know that we have adopted parliamentary form of government. Parliamentary form of government. And the parliamentary form of government that we can say that the legislature is solely responsible to the executive. Executive is responsible to the legislature. Executive, which is known to be a Prime Minister of India, executive head of the government, which is responsible to the executive, is responsible to the legislature. Now, if you talk about Indian judicial structure, India is a single judicial system that is fully integrated. India judicial system is organized in pyramidal structure with the Supreme Court as the apex, which we have already discussed. And here we will discuss about the article in detail, that what exactly the issue is. So if you talk about a court of the future, it needs a law to enforce accountability, which Supreme Court must be given direct responsibility for High Court. So basically, we need to understand that why this article is important, and for what context we will got to know that we have such kind of fair idea that what exactly the article is that we have discussed in the beginning of this is talking about reforms in judicial system in India. Why it required the reforms in judicial system in India? Because it's a kind of British colonial legacy. The Indian judicial system follows the common law system based on recorded judicial precedents as inherited from the British colonial legacy. As we know that the CRPC and IPC, Indian Penal Code, that we have extracted from the British law, and still that is ruling in our country. And hierarchy is that the court system of India comprises the Supreme Court of India, the High Courts and subordinate courts at district, municipal and village levels. And Article 141 that completely says that the law declared by the Supreme Court, it pronouncement on the constitutional validity of enacted law, including constitutional amendments, is binding on all other courts and authorities in the country, which is mentioned in the Article 141, as we can see in the article as well. There is no area of legislative or executive activity which is beyond the highest court scrutiny. And Article 144 of the Constitution, which says that the Supreme Court has a power to hold any authority in contempt if they disregarded or disobey the order of the court. As per the guidelines, there is no law in India to guide our judges. We only have guidelines. So as we know that in India, that after appointing the 50th CJI, it has clearly mentioned the one judges is appointed to another judges. This is what about the article is. Now the data and facts, if you talk about, there are 18 high courts for 28 states and 8 union territories. The British introduced the common law system in India and established the Sadar Diwani Adalat. Diwani Adalat, which means court, which we say in the Hindi. So they were later followed by the establishment of high courts. First high court was established in Calcutta in 1862. As we can know that Indian Institute of Management was also established in Calcutta itself. So first high court was established at Calcutta in 1962. The Supreme Court was established on 28th Jan 1950, and the Supreme Court consists of 31 judges, including the Chief Justice. As we know, Article 124 clearly states that a Supreme Court judge can be impeached by the President, provided the resolutions for impeachment is approved by 2/3 of members present and voting. Two-third, which means that a special majority. There are many majority in our parliament. One is that we can say that simple majority. Simple majority, which means that 50% member present plus voting, and then we can say that special majority. Special majority, the many amendments and changes that we can see in the parliament that is held by the special majority, which required to by third member present and voting. So Supreme Court judge can be impeached similar to like by the president, and we can say with the help of impeachment and approved by the 2/3 of the members present and voting for both of the house in the Lok Sabha and as well as Rajya Sabha as well. Functions of Indian judiciary: upholding and interpreting of the Constitution. The judiciary is responsible for protecting and upholding the Constitution and its ideals. The courts interpret the Constitution and strike down any law, ordinance, rule, or regulation which violates or infringes the constitutional provision. While we're talking about resolving interstate disputes, the Constitution of India lays down a federal structure of government. So what exactly the word federal? As we know that federal, which means dividing power. Dividing power from center to states. From center to state. And as we know that in our India that we have quasi-federal structure. We have quasi-federal structure. And what does it mean the word quasi-federal? Quasi-federal, which means that we can say is completely that we can say quasi-federal, which means we can say that quasi-federal means that it is maximum power is tilting towards the center. The disputes between the states and the union, the states are inevitable. The judiciary, particularly the Supreme Court, plays a key role in resolving such disputes. And while we are talking about protection of fundamental rights, the Part 3rd of the Constitution confers certain fundamental rights on citizens as well as non-citizens and legal as well as natural persons. The judiciary ensures that these fundamental rights are not violated. If any act of the legislature or executive breaches these rights, then the Constitutional Court have the power to issue writs. And as we know, the writs have power as per the in our Constitution, which is enshrined, Supreme Court and High Court have a power to issue writs. So, if any act of the legislature of the executive breaches these rights, then the Constitutional Court have the power to issue writs. And assistance in lawmaking. And what does it mean that assistance in lawmaking is that in several cases the court lay down guidelines which are later incorporated in the states by the legislature, and the judiciary also provides an advisory opinion to the president and resolve any doubts relating to the constitutional provision. Binding value of judicial precedent. Decisions of Supreme Court are binding on all courts of India. This is, make sure you need to remember this one, because in the upcoming CLAT and AILET exam they will definitely ask you such kind of questions and make as a statement. Make sure decision of the Supreme Court and binding to all courts of India. The Supreme Court is not bounded by decision of High Court, lower courts and other judicial authority. As per the Constitution, decision of High Court are binding of all inferior courts. Now, lower courts are bound by decision on higher courts in their own states. So in the lower court, if you talk about the state of Haryana, and if you talk about Haryana, there is some kind of high court. So there is a high court also, and there is a lower courts also. So lower courts bound by decision of higher courts in their own states. So the High Court took given some decisions that can be bound to follow the lower court as well. Decision by high courts of other states hold any persuasive value. So hurdles in judicial systems: overburdened by delays in justice, and litigation is a costly affair. In several instances, the common people are forced to forego their rights and claim as they are unable to afford the legal proceedings, because it requires lots of awareness and we can say money as well. Lack of infrastructure. The judiciary lack the infrastructure to properly deal with a huge caseload The judicial complexes are overcrowded and several courts have a shortage of digital infrastructure. Several British era laws, so they have become obsolete and need to be amended and modified or repealed. Frequent adjournment, the caseload before the subordinate courts are also huge, and resultantly frequent adjournment are granted by the courts, which result in delays. Under trials, if we talk about the under trials, prisoners languish in jails for years while their cases are pending. Ratio of judges to people are very low. There are about 21 judges in India for 1 million people. So that we can say 10 lakhs people is having only one judge. So the ratio of judges to people are very low and need to improve. The ratio was highlighted by the Law Commission in the 25th 245 report. 245th report. The report states that the shortage of judges were leading to a huge backlog of cases, an issue required urgent and immediate attention. And judicial reforms in India, it should be like virtual court, e-courts portal, e-filing, and we can say National Judicial Data Grid, NDJD. E-Seva Kendra is set up as a one-stop center for assessing all the facilities provided under the e-court project. And Interoperable Criminal Justice System (ICJS) was initiated by the E-Committee to transfer data and information about the different pillars of criminal justice system like court, police, jails, juvenile homes, and forensic science laboratories seamlessly from one platform. Way forward, what should we for independence, institutional organization, democracy, rule of law? Because Article 14 says the judiciary in India ensure that there is a rule of law, that is the rights of citizens that should be not violated. Checks and balance, it also keep a balance on other two organs of the government, that is legislature and executive. Shortage of judges should be, there is an urgent need to address the shortage of judges and to ensure that all the cases are disposed on a timely manners. Improving infrastructure, judicial infrastructure, and the working condition of the trial court must be improved so as to attract talent to the judicial profession. Now here is the second article. D.Y. Chandrachud takes charge as the 58th Chief Justice of India. So new CJI has been a part of several constitutional benches. The landmark verdict of the top court described dissent as the safety wall of democracy. He will have a term of 2 years, will have the judiciary until November 10, 2024. So Justice Dhananjay Yashwant Chandra was sworn as the 58th Chief Justice of India. So what is the constitutional provision? Obvious, the Chief Justice of India, the judges of Supreme Court are appointed by the President under Clause 2 of Article 124 of the Constitution. As far as the CJI is concerned, the outgoing CJI recommends his successor and the Union Law Minister forwarded the recommendation to the Prime Minister, who in turn advised the President. The Supreme Court Collegium is headed by the Chief Justice of India and comprises 4 other senior most judges, which we have discussed many times. So this collegium system, there are 5 members including CJI. 5 members, which is 5 senior most judges. The collegium system is a system of appointment and transfer of judges that has evolved through judgment of the Supreme Court judges cases and not by an act of parliament or by a provision of the Constitution. Recent development is that in 2019, Supreme Court ruled that Office of Chief Justice of India comes under the purview of Right to Information Act 2005. As we know that Article 124 Clause 2, the Indian Constitution provides that the judges of the Supreme Court are appointed by the President after consultation with such a number of judges of Supreme Court and of the High Court in the states as the President may deem necessary for the purpose. And Article 217 of the Indian Constitution states that the judges of a High Court shall be appointed by the President, consultation with the Chief Justice of India, the Governor of the state, and the case of appointment of a judge other than the Chief Justice of High Court. While talking appointment of judges of the Supreme Court, Article 124 Clause 2, the article inter alia says every judge of Supreme Court shall be appointed by the President by warrant under hand and seal after consultation with such of judges of the Supreme Court and the High Court in the state of President may deem necessary for the purpose and shall hold office until he attains the age of 65 years. So whether the age should be 65 or we can say the there is no definite age it has been mentioned. And now it's time to questions of the day about the judicial system and all. We have studied lots of articles now, and I hope that you enjoyed the YouTube session a lot. Now, here is the very first question. In context of independence of judiciary, which of the following statement is correct? That the legislature and executive can interfere in the work of judiciary. Second, that we can say the judges of Supreme Court are appointed with the interference from the other branches of government. The courts have no role in ensuring that there is no misuse of power by the legislature and executive. Judiciary plays a crucial role in protecting the fundamental rights of the citizens. So you have to talk about that in the context independent of judiciary. What does it mean, the word independent of judiciary? We have discussed in this time, और अभी जस्ट आपने डिस्कस किया इसके बारे में. So please try to find it out. What could be the right answer? Take your time, 5-10 seconds, then we will discuss. So as we know that we have discussed, fourth one should be the right answer. Judiciary plays a crucial role in protecting the fundamental rights of citizens. The Indian Constitution has provided independence to the judiciary. One aspect of this independence as the separation of powers. It means that other branches of government, the legislature and the executive, cannot interfere the work of the judiciary. So hence first statement is incorrect. The court are not under the government and do not act on their behalf. So the fourth one would be the answer, as we can see it here. The judiciary plays a crucial role in protecting the fundamental rights of citizens. Who was the first Chief Justice of India? Meher Chand Mahajan, A.K. Sarkar, Harilal J. Kania or S.R. Das? Very easy. Okay, so as we know, Harilal J. Kania is the first Chief Justice of India. So Harilal Jagushan Das Kania was the first Chief Justice of India. He was the Chief Justice of India from 1950 to 1951. He read the oath of Chief Justice of India to Dr. Rajendra Prasad, India's first president, and H.J. Kania served as acting editor of Indian Law Reports, or Manda Koluthar Patanjali Shastri was the second Chief Justice of India. Justice Meher Chand Mahajan was the third Chief Justice of the Supreme Court, and Sudhir Ranjan Das, S.R. Das was the fifth Chief Justice of India. So as we got to know, here is a sequence: Meher, C. Mahajan, Sarkar, Kanya and C.R. Das, S.R. Das. So he was the Chief Justice of India from 50 to 51, and it is the oath of Chief Justice of India, and H.G. Kania served Indian Law Reports. Justice Meher Chand Mahajan was the third Chief Justice of Supreme Court of India, and Sudhir Ranjan was S.R. Das was the fifth Chief Justice of India. Now, this is all about the session, and I hope that I have covered all these things in the article about the judicial system and all. But if you have any questions regarding this, so please let me know in the comment section. And apart from that, टेलीग्राम चैनल इज़ देयर एंड आप ऑल इंडिया मॉक टेस्ट इज़ ऑल्सो गोइंग ऑन. सो ऑल इंडिया मॉक टेस्ट के लिए आपको मैं नेक्स्ट क्लास में भी कल डेली न्यूज़ एनालिसिस की उसमें आपको शो हो जाएगी. सो आई रिक्वेस्ट एवरी वन एंड एवरी लॉ एस्पिरेंट्स सो मेक श्योर जो आपके ऑल इंडिया मॉक है यू नीड टू प्रिपेयर फॉर दैट ऑल इंडिया मॉक. उसमें आपको प्रिपेयर होनी है एंड दैट वी विल गिव यू द ऑल इंडिया रैंकिंग भी मिलेगी उसमें आपको, सो दैट यू विल गॉट एन सच काइंड ऑफ फेयर आइडिया कि उसको हमें कैसे देनी है, उसकी एनालिसिस भी आपको खुद से करनी है. एंड अपार्ट फ्रॉम आपको इसमें यू डू नॉट फॉरगेट टू प्रेस द बेल आइकन. जितनी भी आपकी क्लास नोटिफिकेशंस होगी वो आपको मिलती रहेगी उसमें. और वन मोर थिंग दैट करंट अफेयर्स की जो क्लासेस होती है वो थ्राइस इन अ वीक होती है, तो प्लीज़ ट्राई टू वॉच दिस वन ऑल्सो. एंड वन मोर थिंग कि आपको इसमें जो भी चीज़ें एनी इफ़ यू फाउंड एनी डाउट्स इज अकर देन इन दैट सिनेरियो यू कैन लेट मी नो इन द चैट सेक्शन. नॉट फॉरगेट टू प्रेस द बेल आइकन एज वेल. So thank you so much student, bye bye and take care. We'll meet you tomorrow the same time 11:30 AM for daily news analysis. Thank you so much, bye bye and take care.